Good morning, Your Honors. The matter before the court this morning is the case entitled State v. Densmore, case number 23 AP 286. Representing the appellant, Deborah Densmore, is Don Matthews. Representing the appellee, the state of Vermont, is Evan Meenan.
All right, counsel for the appellant, please introduce yourself and your client and then proceed.
Good morning, Your Honors. This is John Matthews on behalf of appellant Deborah Densmore. Deborah Densmore ran an equine rescue operation on her property for many years. She took in horses that were older, retired race horses, and other horses that were headed for kill pens. And she cared for them on her farm in Tunbridge, Vermont. Her neighbor, Lori Berger, made many complaints over the years, ultimately resulting in a 3-day trial in 2022. There are several reasons why this court should reverse Ms. Densmore's conviction, but the most critical, and the one I'd like to focus on, is that the jury was not given an accurate statement of the law in Vermont on what constitutes proper shelter for horses. There's a statute in Vermont that specifically speaks to this. Shelter for horses is defined as all livestock and animals that are to be predominantly maintained in an outdoor area shall be provided with adequate natural shelter or adequate constructed shelter to prevent direct exposure to the elements. That's what the law says about that's what the law says about shelter in Vermont. So after 3 days of testimony from 14 different witnesses, the jury came back after an hour and asked the court for further instruction about the law of structure in Vermont. And the court spoke to the parties, and she said that the court said that they could only give an instruction if the parties agreed, even though this is exactly what the statute says. It's explicit in the statute. And defense counsel a number of times said, well, to me, our case really hinged on whether or not there was adequate natural shelter on the premises. So I'd really like that sentence to be included. And the parties went back and forth about it. And ultimately the court said, well, if the state doesn't agree, I'm not going to give an instruction about that includes that section of the law because you don't agree. So that's curious. I'm not sure that there's no law that I could find that said parties have to agree when the court has asked for the law. To my mind, because the jury came back, that the court had an obligation to instruct on the law. That's what they should have done it in the first place. And then when the jurors came back and specifically asked that question, where there is specific law directly in the statute, I'm not sure that there needs to be anything more than to give the statement that is the law. Defense counsel did not waive that. He made it clear several times that he thought that was an important fact for the jury to know. And in fact, these witnesses who had gone back and forth for 3 days, there were 14 different witnesses. Each gave different testimony about the size of the run-in shed or about the natural tree breaks or about what kind of blankets were provided. And ultimately the court said, well, I want you to agree. And so defense counsel said, all right, I'm not getting the instruction that I want. And he said, okay, judge, go ahead and give the language that you want to give, which is that you've heard a lot about this and you have to use your common sense. But that did not waive the objection. And jury instructions in Vermont should breathe the life and spirit of the law. The jury instruction, without the jury instruction, the jury had to go back and think about or debate whether or not it was okay to have natural shelter in addition to constructed shelter. And for that reason, for 6 of these counts, the jury did not have an accurate instruction as to the law. And for those reasons, for that reason particularly, this court should reverse the conviction. If there are no questions at this time, I'll reserve my time for rebuttal.
All right, very well. Counsel for the appellee, please introduce yourself and your client, and you may proceed.
Good morning. My name is Evan Meenan, and I represent the state of Vermont. Like the appellant, I'll also focus my argument on the issue of jury instructions. As noted in the state's brief, the state agrees that normally in animal cruelty case based on the failure to provide adequate shelter, it would be appropriate for a court to provide three different definitions. The first would be adequate shelter in section 365A, but then there's also two additional definitions. There's one of adequate constructed shelter in section 351, and then there's also a definition of adequate natural shelter in 351. However, it's the state's position in this case that the defendant did not preserve that argument on appeal because pursuant to Vermont Rule of Criminal Procedure 30B, they didn't ask for a specific instruction or object to the trial court's instruction. Now, normally, the state would agree that this court would review that error for plain error. However, I think that there's some particular situations and circumstances in this case that would warrant the court refraining from doing that. And to understand that argument, it really is important to get into the conversation that happened between the court and the parties during the charging conference, or I should say, after the jury asked that question, quote, "What is Vermont law regarding shelter for horses?" Now, when the jury asked that question, the appellant said she wouldn't object to providing the first section of 365A, which is the definition of adequate shelter. There was no conversation at all about the definition of adequate constructed shelter or adequate natural shelter in section 351. So what the court noted was, okay, well, you're not objecting to the first sentence of 365A, but quote, that doesn't define what adequate natural shelter is or what adequate constructed shelter is. So in response to that comment from the court, appellant said, I'm fine with just keeping just the adequate that we have, but quote, she would also be fine with that sentence in subsection A. She did state, I guess my preference would be for the sentence, but she also said, I think if we want to use definitions, then I would prefer that it would be defined that there is such a thing as natural shelter. Otherwise, I'd be fine with nothing. Then the state said, quote, I'm not going to object to anything. And then the court and the parties started to discuss various dictionary definitions, not definitions that were in section 351. And then ultimately the parties agreed to instructing the jury, you should rely on the law given in the instructions to interpret the testimony and evidence presented. As to shelter, we cannot provide a more detailed definition at this time. So it's the state's position that appellant actually withdrew her initial request and then stipulated to what the court and the parties had subsequently discussed. I think that it's important that if the appellant was aware of the definitions in section 351 of adequate natural shelter, she should have had identified them for the trial court rather than waiting until appeal to argue that the failure to provide those definitions constitutes reversible error. And that's exactly what the statement in this court's Casper decision is supposed to prevent. In that case, it said that this court will not, even in criminal cases, consider questions not raised in the court below. If the rule were otherwise, counsel might at times be tempted to remain silent about some fault on the part of the trial court, and so without giving it a chance to correct the situation, arm themselves with a ground for reversal if the situation should go against them. That's exactly what happened here. Appellant remained silent on the definition of adequate natural shelter and now is trying to obtain a reversal of the conviction. In my 1 minute remaining, I'd like to address the state's argument about harmless error. Now, in this case, we're only arguing that the error would be harmless with regard to the convictions for Winky, Midnight, and Cashmere, because with respect to those horses, appellant was convicted of failing to provide them with adequate food and or medical care. And the sentences for those failures was the same as the sentences for the failure to provide shelter. And also, and this is important, the forfeiture order applied to all of the seized animals, and appellant has not challenged that aspect of the forfeiture order. So even if the 6 convictions for shelter were reversed, that would not be grounds for reversing the forfeiture order and ordering that any of these horses be returned to appellant. And if there aren't any questions, I see that I have no time remaining. Thank you very much.
All right, thank you, counsel. Does the appellant have any time remaining?
Appellant has 30 seconds remaining.
All right, counsel.
The error was not harmless in this case because there were 6 counts and the jury spent a significant amount of time on this. And I believe that if the court were to reverse those 6 counts, there should be a new trial because of all of the information that got out and was contemplated. To me, this was not a waiver, and I would agree with the state that you should go back and look at those 10 pages from 115 to 125 of the transcript. And if you do, you'll see that this was much more like State v. Campbell, where the defense counsel simply acceded to what the judge was going to do and moved on. I see I have no time remaining.
Thank you very much. Bailiff may call the conclusion of the case.